Hello, everyone, and welcome to week 10. This week we'll be focusing on the judicial system, completing our tour of the three branches of government before next week we talk about state and local governments. This first lecture is going to talk about the structure and process of the federal judiciary. And the next lecture is going to be talking about questions of constitutional interpretation. So hopefully at the end of this lecture, you'll be able to describe the design and function of the federal judiciary, the role and practice of judicial review, and thinking a little bit about the politics of the Supreme Court in particular. So starting with the structure of the judiciary, the judicial system can be distinguished between two main systems. The civil system, in which is where we have litigation of lawsuits. You have lawsuits, plaintiff versus the defendant, and these are resolved through civil remedies, assessment. You have to pay damages if you're found liable, versus criminal, where you are charged with a crime, you are prosecuted on behalf of representatives of the state, and that you face criminal punishment up into capital punishment, losing your life. A lot of time we kind of think of the justice system through the language of the criminal system, but the civil justice system is where a lot of kind of constitutional law ends up happening, like lawsuits over the enforcement of a particular law that leads to a law being struck down as constitutional or unconstitutional. Most of that happens at the civil law, in the civil system, not the criminal system. So the U.S. has what's known as a dual court system. On the one hand, we have a state court system. Each state has its own court system here that begins from state trial courts or county trial courts. These are known as superior courts. These move up to immediate courts of appeals at the state level and then can be further appealed to the state Supreme Court. If the question involves application of federal law, further appeal can be made to the Supreme Court of the United States. Most cases are done in the state system. The Supreme Court only holds, clear my drawings here, only holds jurisdiction, what is known as original jurisdiction, in which they hear cases for the first time in very rare disputes between states or between the federal government and a foreign national. In all other cases, they have appellate jurisdiction, so the case has to begin in either the state or the federal system. The federal system involves questions of federal law. The cases begin in one of the 94 different district courts, and appeals are made to one of the 13 circuits courts of appeals, which are organized geographically and whose judges have lifetime appointments. And again, appeals can be made to the Supreme Court. Now, Supreme Court appeal is not automatic. The court must issue what is known as a writ of certiorari and agree to hear the case. This is known as granting cert. And granting cert doesn't mean the Supreme Court disagrees with the lower ruling. They just means that they will review the decision, and that just requires a majority of the justices. Sorry, not a majority. Not a majority, sorry, it's the rule of 4. You need 4 of the 9 justices on the Supreme Court to agree to hear the case for it to come up to be reviewed by the Supreme Court, and less than 10% of requests for review are usually granted. So most case law, most decisions happening in either the state court system or the federal court system, not at the Supreme Court level. This framework was established by the Judiciary Act of 1789 and established this basic structure of the federal judiciary, and it's still mostly followed today. In one of the early important cases heard by the Supreme Court, Chisholm versus Georgia, the court upheld that the federal court system could hear cases that brought against citizens of other states, and that states were not protected by lawsuits. This was actually eventually overturned by the 11th Amendment, which states that the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or citizens or subjects of any foreign state. But you have these early kind of questions of what is the role of judiciary, because Article 3 is really vague on what the power of the judiciary really is. Chief Justice John Marshall, the first Chief Justice one of the first Chief Justice of the Supreme Court, was really interested in expanding and strengthening the Supreme Court. In the kind of famous case of Marbury versus Madison, the Supreme Court ruled that it itself has the power of judicial review, that it can strike down an act of Congress if unconstitutional. And it did so more or less by claiming this power through an act of judicial review. It basically ruled that Congress had acted incorrectly. The court, this was the first time the court declared an act of Congress unconstitutional and thereby established that this is something that the court system has the power to do. Wielding this power, Marshall wrote, is the very essence of judicial duty. Hamilton defends an implied right to judicial review in the Federalist Papers, but it's not in the Constitution itself. And this becomes a key idea this is kind of what we associate the judicial system and the court system with today. So if we're thinking of if we're going into more detail on the federal court system, this is what we're going to be focusing on. Again, we start with one of the 94 U.S. district courts. These are the trial courts of the federal system. They hear cases. These are overseen by a single judge. Appeals can then be made to the U.S. Courts of Appeals. There are 13 judicial circuits. So when you hear people talking about like the 9th Circuit or the 12th Circuit, this is the appellate courts. These are rotating 3-judge panels that oversee these appeals, and then they can be appealed to the Supreme Court, which currently has 9 justices, including 1 Chief Justice, and they make binding decisions that set precedent for all lower courts. And as your textbook talks about, the kind of idea of precedent always goes, this way, that lower courts are always bound by the precedential decisions of the higher courts, and we'll talk about this a little bit in the next lecture when we talk about common law. But this matters in that a district court has to follow the precedent set by a court of appeals and has to follow the precedent set by the Supreme Court. It doesn't work the other way. So appealing a decision is challenging that the ruling was correct on the basis of law, not fact. And the appeals courts accepts the facts as they are presented in the original trial. They do not hear new evidence about the basic facts unless there was some claim that their evidence was gathered incorrectly. Instead, the role of the appeals court is to determine whether or not the law had been correctly applied in that case, or if the law itself was constitutional. And over here, we have the geographic boundaries of the different appellate courts of appeals. So these different circuits, right? So that if you are in California, you are part of the 9th Circuit Court of Appeals. So rather than having a full trial, the sides submit legal briefs outlining their arguments that are reviewed by the appeals courts. Then there are brief oral arguments. These are kind of famous at the Supreme Court level. There are oral arguments in which each side presents their brief. It's usually about 15 minutes, and are asked questions by the justices hearing the case, whether it's the Supreme Court or the 3-judge panel. Most appeals are heard by a panel within the appellate court of 3 judges. Occasionally, if there's a concern about inconsistent rulings, there will be what's known as an en banc hearing in which all of the judges of that circuit will hear the case. So this is more rare. So a court can make a bunch of different rulings. They can affirm a lower court ruling where they basically agree with the result of the lower courts. They can reverse a ruling where they basically disagree with the results of the lower court's ruling and overturn their decisions. They can also vacate a ruling and overturn the lower court's rulings as invalid without necessarily disagreeing with them, but making a claim that the case was decided on a legal principle that no longer applies. Perhaps a law was appealed or a law was changed. That means that that lower ruling will be vacated. Or they can remand it. They can send the case back down to a lower court to be reheard at that level. So when the courts are making rulings, they can rely on multiple sources of law. These can be the constitutions, both the state and federal constitutions hold supreme authority and determine the scope and extent of the powers of the state or federal government. Judicial review can often turns on whether or not a law was authorized by the Constitution. Most law comes from statutory laws, so different laws passed by state and local governments. but also administrative regulations, things like the Clean Water Rule that we talked about last week. Treaties are binding sources of law once they are signed. Executive orders, not technically, they are not acts of Congress, but they have the force of law. Appellate court decisions are binding, right? So the decision made by an appellate court on interpretation of law becomes a source of case law, and we'll talk about this more in the next lecture. And precedent. The courts can cite previous decisions to guide their decisions in future cases. These precedents establish certain rules or decision-making rules, like the Lemon Test for free speech, that can guide the judgment of future decisions. So in Federalist 78, Hamilton writes that the judiciary is the weakest of the three branches. It has no influence over either the purse or the sword. And so it is always at the risk of being overpowered by the political branches. But he also insists that an independent judiciary is necessary to maintain a limited constitution, and that it is necessary, and that's one where the legislature doesn't have absolute authority to do whatever it wants, but because the legislature cannot act in any way that is contrary to the Constitution. So this is an implied power of judicial review, that the interpretation of the law is the proper and peculiar province of the courts. The purpose of an independent judiciary is to limit the laws to those powers established by the Constitution, and to review and interpret those laws to make sure that the legislature had acted correctly. In this essay, Hamilton also argues that the tenure of good behavior secures judicial independence. That what is necessary is that you need to have an independent judiciary outside of the political process, who are not reliant on getting reappointed by elected representatives to the judiciary in order to make rulings based on the law and on the Constitution rather than on their own political convenience. And so the idea of lifetime appointments to the federal judiciary is based on this idea that the justices ideally should be independent of the political process, that they should be outside of political concerns and making rulings purely based on an inflexible and uniform adherence to the Constitution. So what is the judiciary reviewing when they're engaging in judicial review? Well, they are often interpreting the law. There might be ambiguous statutes. The law might be written in a way where it's unclear what it's telling the executive agency to do, or what exactly it means, what the law means, right? In the cases about the Affordable Care Act, there was a lot of debate over what exactly is the penalty for not having health insurance. Is that a tax? Is that a fine? And that matters in terms of the constitutional authority of the law. If there are contradictory statutes or conflicting interpretations of the statutes, in general, they're asking kind of like, what does the law mean? What does it mean to take or harm an endangered species, for example, in the Endangered Species Act? Does that include harming a species environment, or does it only include literally harming directly that species? And is that statute constitutional? Is it made in accordance with the authority established by the state or the federal Constitution? But they're also reviewing specific actions taken by executive agencies. And the first thing that they're looking for is how the agency, in enforcing that law, has interpreted the law. And this receives the highest scrutiny. Has the agency interpreted the law correctly? Now, in general, since the 1984 case of Chevron versus NRDC, the courts have basically affirmed the right of executive agencies to interpret the law when Congress has left the question open, when Congress does not define a key word or phrase in the law. This idea is Chevron deference, is that they will the courts will defer to a reasonable construction of the law made by that executive agency. They'll also review the agency's fact-finding on a particular case. This receives the lowest scrutiny. Why? Because the justices on the Supreme Court or the appellate court are not experts on the facts of the case, and they are not experts on, water pollution, for example, or on healthcare policy, right? They're not disputing necessarily the facts, but they're disputing, again, the question of the law. And they're evaluating whether the agency's use of discretionary power to apply the law was in accordance with the law. And in general, they defer to executive agencies unless the action was arbitrary, capricious, and abuse of discretion, otherwise not in accordance with the law. So judicial review doesn't automatically. So how does that actually occur? The first question that gets asked is a question of standing. The court has to determine who has the right to sue. The plaintiff must establish an injury in fact in which they have actually suffered an injury, an invasion of a legally protected interest that is concrete and actual and not hypothetical. This can be economic, non-economic, or both. Excuse me. There has to be a causal connection between the injury and the conduct complained upon. You can't just sue someone because you fell and got hurt. There has to be a causal connection between your injury and the agent, the company, or the person that you're suing. And there has to be redressability or compensation. You actually have that. There has to be a idea that you can actually redress the injury through some sort of redress. Second, the courts are determining which cases are ripe for review. Again, this is determining whether or not there is an actual injury or harm rather than just potential consequence. And this was defined in a 1967 case, Abbott Laboratories versus Gardner. A claim is not ripe for adjudication if it rests upon contingent future events that may not occur as anticipated or indeed may not occur at all. The idea here is that the court is always going to be a question of redress, not like some potential future where the harm might occur. The court then determines the standards of review or how much it's going to defer to the agency interpretation of law or existing interpretations of law. They're going to offer an actual interpretation of the law based on these standards, and we'll talk about this in next class about the politics here, but what does the text mean? What was the legislative intent behind the law? And making sure that their interpretation is consistent with prior precedent. Finally, they're going to rule and assign remedies. They might be financial damages. They might be some sort of case in which they might be award the victims of victims of some sort of negligence or malpractice, financial remedies. They can also rule that a law is unconstitutional or improperly applied here. So again, the case selection is always going to be a function of this rule of 4, the granting cert. The Supreme Court does not just automatically take every case that is appealed to the Supreme Court. Briefs are then submitted to the Supreme Court, including what are known as amicus curiae briefs. These are friends of the court. It means that briefs are not just by the plaintiff and the defendant, but briefs are also submitted by interested third parties who have some interest in the case. Oral arguments are heard between October and April, and these are a question and answer more than a formal presentation. And then the Supreme Court meets in conference twice a week when in session, once a week when out of session, and this is when they make their kind of rulings, their decisions. They meet in conference. And in the court decisions themselves set precedent. The reason for the ruling can be as important as the rulings itself. And we'll talk about this more in the next lecture. The opinions can be the majority opinion, the decision, the opinion explaining the decision of the majority of the courts in their ruling, a dissenting opinion, someone who was on the losing side of a 5-4 decision explains why they disagree with the reasoning, or they can have opinions that are concurring, that they agree with the majority, but for different reasons. Now, with Hamilton's protests to the contrary, the court is political. And I want us to think about the politics both as an input and as an output of court decisions. So as an input, the appointment process, right? Presidential nominees, they're nominated by the president and subjected to the Senate's advise and consent power. And these nomination fights have become increasingly polarized. If we look at some recent members of the court, Antonin Scalia was confirmed to the Supreme Court with a vote of 98-0. Justice Sonia Sotomayor by a vote of 68-31, which is increasingly polarized, but not all that bad. Merrick Garland, President Obama's last nominee to the Supreme Court did not receive a vote. There was no vote on that nomination. Neil Gorsuch was confirmed 54 to 45, and Kavanaugh was confirmed 50 to 48. Now, of course, there were other both of these decisions had additional, the politics of the Trump administration, the Garland lack of vote, the allegations of sexual assault by Justice Kavanaugh. But there are also political considerations for both the president and the Senate. Who's the president going to nominate? They might have run on promising particular sets of justices. The senators have to go back to their constituents and justify whether or not they agreed with a particular justice, right? It's not simply a question of, is this person a qualified legal mind able to interpret the law correctly? The politics here matters. We also have to think about the politics of judicial opinions, both their judicial philosophy and their political opinions. The justices are people too. But also, the court has to work to maintain its own legitimacy. The court can't enforce its own decisions, so it relies on the perception that it is apolitical in order to get the other political branches to do what it says, basically. When it commands that Congress, the president, the executive branch do something, or commands Congress to do something, it's relying on this legitimacy. And so if the court is perceived to be super political by making a bunch of controversial political rulings, it's going to lose that legitimacy and lose its power of enforcement. The court can also be stripped. The Congress controls the budget of the court, and so Congress can start taking money away from the federal judiciary. Those resources are necessary to hire staff and pages, etc., and clerks that are going to be valuable. So they don't want to be stripped from those resources. The famous story of Earl Warren in the Brown versus Board of Education decision, that he, for the purposes of the legitimacy of the court, given that he knew this was going to be an important and controversial ruling, he wanted it to be a unanimous decision. And so he personally lobbied all of the justices to make sure it was a unanimous decision. Right now, Chief Justice John Roberts is often stated that he is very concerned with the legitimacy of the court, and so many of his rulings where he will side with the more liberal wing of the court rather than the conservative wing, despite himself being more conservative, is out of an attempt to try to maintain this view of the court as apolitical. But politics is also an output, right? Decisions have consequences. Rulings affect policymaking with real material consequences when you strike down a law, strike down parts of the law, such as the Medicare expansion and the Affordable Care Act, that changes how the law actually functions. When you strike down parts of the Voting Rights Act, that changes how the voting rights get protected in different states, right? This can prohibit agency or executive actions, award damages. These have real material consequences. There also is the politics of perception here, how the court is perceived as being an activist court or a restrained court. It affects how legitimate it is. And there's also what is known as the hollow hope, after the political scientist Gerald Rosenberg's 1991 book. And he argues that despite our kind of opinion of the court as based on decisions like Brown versus Board or Roe v. Wade or Obergefell more recently, as like, oh, you go to the court to achieve civil rights, that the court is actually highly constrained in achieving social change. The court relies on Congress to actually pass laws to realize these social changes, things like the Voting Rights Act, things like the Civil Rights Act, things like various enforcement measures by executive agencies. But what ends up happening is that high-profile rulings act as flypaper for activists, luring movements for social reform to an institution that is structurally constrained from serving their needs, providing only an illusion of change. So you have these high-profile rulings that don't actually change the underlying thing, and they attract interest groups and activists moving to the judicial branch rather than moving to the legislature, focusing on lawsuits and litigation rather than winning elections and passing laws. So next lecture will be on how justices interpret the court, interpret the Constitution and laws, different judicial philosophies, and why these matter politically. But that's it for this lecture. Take care.